Hello, everyone. Welcome to Joe the Lawyer. I am your host, Joe Pometto, a practicing Pittsburgh attorney. I do criminal defense, family law, personal injury, and a little bit of everything. If you have a question, come on in, check out my podcast. Ask me legal questions. We can talk about politics. Mostly I'm here though because I want to hear your legal questions. I know I didn't announce today, but I'm going to try to go live pretty much not every night, but a couple nights a week at 8 o'clock. 8 o'clock Wednesday was my original time when I was doing the Common Sense Academy. So I'm back for at least a half an hour today. Those of you who like to correct me when I talk about Diet Coke, today I got my trusty Diet Pepsi. Not healthy, not good for me in any way whatsoever, but it could be worse. Cheers. Okay, very delicious. What do I want to talk about today? Let's see. What did I work on today in my law practice? Well, I had to deal with service of process. That's always fun. Let me know if you think service of process is interesting. I could talk about it for a while. What I have here, here's the funny thing with service of process is people try to dodge it. People try to dodge it, right? And most oftentimes I see it in family law cases, all right? So you got a mother and a father, married, maybe unmarried, usually unmarried in this situation, but not always. And one of them wants to file for custody of the child. One of them wants to file for custody of the children. And the one who files has to get service on the other one. The one who files has to get service on the other one. Well, oftentimes, of course, these people run in the same circles, got the same friends, okay? And dad is trying to get service on mom, and mom is trying to avoid service, right? So first you send it by certified mail. They won't sign. You send it by restricted mail. Same thing. They won't sign. They avoid it. Then you send a process server to their house to try to serve them with papers, and they don't want to take it. This is just like some of the videos we watch in Sovereign Citizens where a sheriff comes to the house to serve process and the person won't take it. It is hilarious. These people try to avoid service. Here's the thing. If you avoid service, it actually it creates friction, right? An artful dodger. Very good, Beverly. How you doing? Thanks for hopping in. An artful dodger. Okay, it creates friction. It does make the job of the other side harder. However, if the other side has just a little bit, a tiny bit of determination, they're going to get that paperwork served. They're going to get it served because if this person is dodging, all you got to do is go in there and tell the judge, hey, judge, they're dodging, and the judge, boom, can issue an order. Or they can do service by publication or alternative means. So when you do that, you go into the court, you file a motion, you ask the judge, you say, look, judge, this person's hiding from my complaint. I'm trying to file for custody of my children and they're dodging, they're hiding. So what do? You ask for alternative service. If that's the case, boom, you can serve by regular mail. Boom, you can even serve by publication, which means you put it in the freaking newspaper. So I just find it hilarious. I have a case right now. I'm litigating it in court. And what happened was I tried to serve by certified mail to an individual's address at a secured building. So the person lived in this apartment building where the entire building is secure and there is like a manager or a desk person or a secretary. And the mail comes in and the secretary will sign for the mail and then deliver it. Well, I sent something certified, secretary signed for it, okay? And lo and behold, the person who lives in the building says, I never got it. I never got it. I never received it, okay? Come on. All right. So I got this signed certification receipt. I'm like, boom, here it is. I got service, everybody. I got service. Well, they're still fighting me. We've done multiple motions and arguments before the judges here in Allegheny County trying to say that he isn't served. All right. the funny thing about this, and this is the art of being a defense attorney, okay? Now, I don't generally benefit from this, and I'm pretty honest with my clients. And what do I mean? What am I talking about? Well, defense attorneys love to bill their clients. They love opportunities to do work on a case and then justify it to the client. Yeah, pay me $100 an hour. Yeah, pay me $150 an hour. Pay me $200 an hour to do this or to do that. All right. And so this guy is fighting me on the case. The top value of the case is only a couple $1,000s. This guy is going to fight this case. Okay, going to fight this case and is going to spend more on the lawyer than he would have had to spend to settle the case. But here's the funny thing, and I can respect this. I respect this, okay? Some people say to me when they hire me for defense, they're like, Joe, I'd rather pay you $10,000 than to pay this person who's suing me $50. Right? They say, listen, I'd rather pay you, my attorney who's fighting for me, $10,000 than pay the person who's suing me $1,000, $500. I get people who say that all the time. So people get angry about lawsuits. Lawsuits, a lot of them are irrational and personal, and emotion overrides logic. Now, not always, or even I would say most of the time, but I'd say at least 1/3 of lawsuits, 1/3 of cases that go into litigation are driven by anger. All right. And the ones that settle for the most part are the ones where the people are being very rational actors. Right. And that's where the attorneys come in, because the attorneys can come in and hopefully, if they're honest, they're good lawyers, they'll attempt to talk some sense into their clients. So the client isn't just so angry at the lawsuit, like just dropping money into it, So, it's just funny. I've had cases. So I did employment law, and in employment law, a lot of what I'm doing is suing employers for violations of Title VII of the Civil Rights Act. So and I did this for about a year. I only take a select few employment cases nowadays. But for example, let's say someone has a disability, all right? And I'm trying to think of something good. Here's an interesting one, like Crohn's disease, okay? Crohn's disease is interesting. It is a disability, but it's interesting because it's not completely debilitating, but it can cause a person who goes to work to periodically have to take days off and call in sick more often than a person without Crohn's disease. It's a valid disability. So, employers will end up firing this person. This person comes to me and we go after them. We say, look, you fired my client because they had Crohn's disease. That's unlawful under the Americans with Disabilities Act, the ADA. So pay us our damages, lost wages, attorney's fees, etc. And if they feel that was not the reason for the firing, oh my, they get mad. Emotion, anger. You suing me over this. This is BS. I did not fire you over your Crohn's disease. I fired you because you were a bad employee. You were late. You didn't do your work right. Da, 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 da. And so emotion overtakes. What I'll tell you in lawsuits is that oftentimes emotion will rule early in lawsuits, especially in family cases where it's like both sides are extremely angry. But as weeks and months go on and people spend more and more money, then they start to come to their senses. Not always, but sometimes. That's what I have seen happen. I can tell another story like that. Give me a second. But anybody there? Only person I see in my chat is Beverly. Beverly, drop me a question if there's something you want to talk about. Anybody else? I got 3 people in the chat room. If you're something you want me to talk about, you have a legal question, something that's bugging you that you want to drop off to a lawyer, go ahead, drop it in my chat. In the meantime, I will keep on talking. So I had a case one time where a wife, boom, filed a PFA against the husband, a protection from abuse order. It's a restraining order. In Pennsylvania, they're called PFAs. Boom, hits this guy with a PFA. So he's so angry and emotional, and I really don't blame her. He comes to me and he says, boom, like, Joe, I want to hit her with a divorce. So boom, I hit her with divorce. And then boom, she hits him with custody. And all of a sudden we're in court over a PFA custody, divorce, the whole shebang. He's out of the house. She's in the house. Who's going to pay the mortgage? They're fighting over the mortgage. All right. This other lawyer who's been practicing a lot longer than me, and he can see this in the cases. And this is something I'm starting to build up. We go and we do a couple of motions, and we're in the back room chatting. And he goes, Joe, he goes, in 2 weeks, they're going to make up. And I'm like, I don't think so, man. My client is angry. He's upset. Joe, in 2 weeks, what happens? We file a couple more motions. Then 2, 3, 4 months go by. I don't hear from my client. He is, okay. A year goes by. I don't hear from my client. The case is just in stasis. The other attorney calls me up and he says, Joe, what happened? He goes, what are we doing with this case? We have this case. What are we doing with it? I go, I haven't heard from my client in a year. He goes, I haven't either. He goes, they must have made up. Okay. And we administratively closed everything. Kind of hilarious. But in family law cases, that's often, they start out fast, furious, full of emotion, and then sometimes they make up or cooler heads prevail. But it takes time. It takes time for cooler heads to prevail. So anybody got a question? You want to bounce something off a lawyer? Go ahead, drop something in the chat. Let me know. If somebody wants to call in just to talk about the law, I know this was kind of I didn't advertise tonight, so I don't have that big a room, but I'm trying to build up this channel, so I'm trying to come on here and be a bit more consistent. All right, Beverly, I love you. Thank you very much. When you can't resolve a problem, you feel that the children should be exposed to all the crazy. Well, Beverly, I don't feel that they should. Unfortunately, in my role as a lawyer, there's only so much that I can do. I can try to talk to my client so that cooler heads will prevail. I can advise them, and then it's their choice. But when the parents are exposing the children to this sort of divisiveness and this sort of legal combat, there's really not much I can do. The lawyers are kind of stuck in the middle, and we can see it sometimes. And we can say to our clients, I can say, look, and I've said this, I can say, this is going to be rough on your kids. Let's try to find a resolution. And oftentimes that works. Not always at first, like I said. When emotions cool down, then the parents will come to, and then the attorneys can get together and work out a deal. But early on, that can be difficult. And sometimes the parent, for one reason or another, will not let go and will continue the combat. And it can put the kids through a lot. It can. But that's the parent's choice. I can tell you, I almost always tell my clients, look, do you really want to do this? Do you want to put your kid through, months, years of litigation, have them that come to a trial or choose between mom and dad? It can be heartbreaking. It can be really, really brutal. Personally, my personal opinion, no, I wish the kids weren't exposed to it. And I ask that most cases, and I try to get most cases to come to an early resolution, but sometimes it's not always possible. And sometimes it's just one parent who's being extremely unreasonable, but sometimes it's both of them, okay? It's both of them. And hopefully, if there's good lawyers on both sides, it can allow cooler heads to prevail. So thank you, everybody, for tuning in. This is Joe Pometto. This is Joe the Lawyer live. If you have any legal questions, I got a couple more people in my chat room. Go ahead and drop me a legal question in the chat. Something you want to know about, anything that you're curious about. Otherwise, I will sit here and continue to talk my face off, because I'm guaranteeing 30 minutes every live stream, 30 minutes. Come in here, ask me about legal questions. I can talk about politics. I can talk about current events, but really, I want to provide legal advice if there's something somebody needs. Cheers. Long day today. So I was talking about this in my live stream yesterday, and I want to talk about it again, where out in California, this really just fascinates me for some reason. Most of the big tech firms are in and around San Jose and San Francisco and Silicon Valley, okay? You got these big tech firms. I don't think it's any secret that these tech firms are run by individuals who would describe themselves as Democrats and on the left side of the political spectrum. And there was this case out of California where an Apple executive, the head of security, one of the head of securities at Apple, the global Apple iPhones, all right, was donating iPads to a sheriff's office, donating iPads to the sheriff's office in exchange for concealed carry permits, Now, the official story is, and I have to give credit to law enforcement in this case, because I believe the district attorney and the local county police, they're actually bringing charges against the sheriff's department. So their charges are not only against the executives at Apple, but they're also bringing charges against the sheriff's department, which is a rare thing for law enforcement to go after law enforcement, even if that other agency is breaking the law. So I got to give kudos to the agency that is prosecuting this case. Anyway, the official story from Apple is, what they're saying is that they make donations of iPads to all types of law enforcement agencies. All right, so this is just their regular. Excuse me, I'm drinking Diet Pepsi, so I keep burping. This is just their regular order of business, right? Is we donate iPads to law enforcement, we donate iPads, we donate things to all sorts of companies and organizations. I'm sure they do. And the sheriff's department is saying every single concealed carry permit that we gave was in line with the law. Every single concealed carry permit was in line with the law and the regular process. But here's the kicker. Out in that county, all right, and I'll post the article, but out in that county, it is very difficult to get a concealed carry permit. Frankly, I'm surprised you can get one anywhere in California, okay? They're so liberal out there. Anyway, but I'm surprised you can get a concealed carry permit anywhere in California, but you can under limited circumstances, and it's very strict. And so that's why this raises the specter of corruption. I bet a deal is reached. I bet both the sheriff's office and the executives over at Apple, this guy was like the head of security. I see guilty pleas coming. I don't see them going to trial. I see them pleading guilty, probably avoiding jail, but that I do believe that there will be convictions here, okay? That's just my personal opinion. They may have some good defenses, and their lawyers are out there right now throwing defenses at them, but I think there's going to be a deal hatched. I think there's going to be a deal. I mean, it's just funny. It's interesting to me because here in Pennsylvania, Second Amendment's a big thing. Allegheny County, anybody can get a concealed carry permit. Anyone can get a concealed carry permit. Basically, a criminal background check. There may be like a mental health check too. I'm not exactly sure. But you apply, you fill out a form, they run your background. If you have a clean record, boom, you get the permit. And I believe you have to pick it up. You have to renew it once a year. So this story is just, especially in California and Apple being what I consider, and listen, I'm a big fan of Apple products. I really am. I think they're a great company. They're American company. All right. They're part of Silicon Valley, and they're out there trading iPads for concealed carry permits. I don't know. It's hysterical and bizarre in a way, and also tragic. Okay, let's see here. Shepherd's Voice, thank you for the very nice words. If you want to ask a question, go ahead and drop a question. Let's see, from Mark. Why am I still hearing about voter fraud in PA? Is there any way to Trump's claims of fraud anywhere? Well, I don't know, and I haven't looked at each one individually. I'll tell you the interesting case that was filed here. So I'm going to talk a little bit about, and I know this is the hot thing, and I got to read up on it, okay? I'd have to really read on it to talk about it, but in really good detail. But anyways, one of the lawsuits in Pennsylvania, which was filed by Sean Parnell, claims this is, and it's a big ask. It's a big ask. It's saying that vote by mail is and was unconstitutional. Vote by mail is and was unconstitutional. And if the Supreme Court, now the interesting thing about this lawsuit is If it succeeded, it likely would turn the course of the election in Pennsylvania. So it could flip Pennsylvania to Donald Trump. Because if the Supreme Court said, Supreme Court of Pennsylvania and or the Supreme Court of the United States, if they said, look, the vote by mail scheme put in place by the legislature is invalid, they could issue an order invalidating all the votes that were sent by mail. And if that was a success, Donald Trump would likely win, because my understanding of the vote count in Pennsylvania is Trump was ahead in in-person votes. Trump's here, Biden's here, and then the mail-in votes come, and Biden moves ahead and wins the state. Okay, so if you invalidated that margin, it would give Pennsylvania to Donald Trump. This is a huge ask, Number one, they're asking for the court to not only find mail-in voting constitutional, but they want it to apply retroactively. Oftentimes, when the courts take, for example, two prominent decisions, abortion, Roe v. Wade, and the Obergefell decision, which legalized gay marriage. Most decisions by the Supreme Court or an appeals court in Pennsylvania, any state, nationally, are going to start from the day the court makes the decision going forward. They usually don't go back in time. They're usually not retroactive. So, the Supreme Court of Pennsylvania could look at this law and say, well, you know what? We do think it was unconstitutional, but we're only going to apply it going forward, not backwards. Okay. That's one possibility here. But it's a big ask to ask for something to go retroactive. Obergefell, when it said, okay, you can have gay marriage, boom, going forward. It's legal going forward. All right. But like anything that happened in the past is forgotten. Sometimes that'll happen in the criminal law, right? They'll pass laws changing penalties for, like, let's say the possession of cocaine. So in the future, there's no mandatory penalty for cocaine. But if you got a mandatory penalty in the last 20 years before that, the law generally doesn't help you. That's how a lot of Supreme Court decisions work. They only operate from that point going forward. But what the Sean Parnell lawsuit in Pennsylvania is asking is to not only declare the mail-in voting unconstitutional, but to also apply it retroactively so that the mail-in votes in Pennsylvania are discounted. Here's a couple of problems with it. Number one, the scheme that allowed mail-in voting in Pennsylvania was set up by the legislature. My understanding, and I don't have all the technical details. I could get it. I mean, I could read them and understand them, but I haven't done that, okay? But my understanding is about a year, 2 years before the election, the Pennsylvania state legislature got together, Republicans and Democrats, and a kind of deal was made. The deal was this. Republicans said no more straight ticket voting. So I don't know if that's something people in Pennsylvania, that's where I'm from, Pennsylvania got rid of straight ticket voting. So now you have to vote for each and every individual candidate. Okay. And the Republicans thought that would help them. And at the same time, they made mail-in voting legal. It made mail-in voting legal. Republicans and Democrats were on board with this. So this law passed with bipartisan support that allowed for mail-in voting in Pennsylvania. Okay? Also, there was a clause in the legislation, in the law, that stated that anybody who thought that this law was unconstitutional should bring forward, and I don't know the time limit, it was something like 180 days. Within 180 days from the act being passed, okay, there was 180 days where it said, if you believe this law is unconstitutional, please bring forward these claims now. And nobody did. Republicans didn't. Democrats didn't. There wasn't a lawyer hired by anyone or anything to come forward and say that this act was unconstitutional. And they created what we call, you could almost refer to it as a sunset clause. They put a clause in there. They said sunset means it runs to a certain point and then the sun sets and it's over. Okay. Now that's not that strict, but it does help. It makes it harder to challenge it unconstitutionally when you were supposed to do it within this 180-day window. You can still bring the challenge, but again, it's much harder to make that leap now for the court. Another problem with this lawsuit. Crap, I had it in my mind and I forgot. Let me sip my Diet Pepsi. I'm trying to think. There was one more problem with the Pennsylvania lawsuit. The sunset clause. Oh, I remember. So when the lawsuit, and here's perhaps the biggest problem for the Trump campaign, Sean Parnell, the parties who are bringing this lawsuit. The biggest problem is the mail-in voting portion was in effect during the primaries. Okay, so we had the primaries in the spring and then the general election in the fall. Well, in the primaries, mail-in voting was allowed, and not the same Republican who's bringing this case now, Sean Parnell, okay, after he won his primary and he didn't say anything about the mail-in voting. He won his primary and he didn't say anything about the mail-in voting. So they allowed the mail-in voting scheme to stay in place for the primaries, arguably when it benefited them. And then in the fall, when it didn't benefit them, they said, oh, hey, this is unconstitutional. So those are some big factors working against the lawsuit. Number one, it was passed through the mail-in voting scheme was passed through the regular legislative process with both Republican and Democrat support. Number two, there was a sunset clause in there saying you should challenge this constitutionally within a certain period of time, and nobody did it. Then several elections passed, including a primary where the mail-in voting was performed, and no parties objected to it at that time. And lo and behold, in the fall, somebody wants to raise the specter of it now being unconstitutional. Now, let me say this. If the court does a really thorough analysis and decides it's unconstitutional, none of that necessarily matters, right? If they're looking strictly, okay, but most likely there's nothing unconstitutional about this scheme. Under the United States Constitution and generally, states have wide leeway in how they wish to run their elections. Wide leeway. For instance, a state like Maine, they split up their electoral votes, right? Some states, it's winner takes all. Some of them split up their electoral votes. In some states, independents can vote in primaries. In other states, independents cannot vote in primaries. In some states, there is mail-in voting. In some states, there is not mail-in voting. In some states, you can do a straight party ticket. Some states, you can't. So the Constitution, the United States Constitution allows vast leeway for states to determine the method of voting. So I would be shocked if that lawsuit wins. Now, the thing about that lawsuit is if it did win, it would change who won the state of Pennsylvania. Whereas a lot of the smaller Donald Trump lawsuits aren't going to make a dent. Like in some of the states, they're arguing that the signatures didn't match. Okay, you might knock out a couple thousand. All right, you might knock out a couple thousand. But a couple thousand, I mean, in most of these states, Trump lost, the states he's challenging, he lost by 50, 60, 70, 80,000 votes. So you can't just knock out a couple hundred votes. You can't just knock out a couple thousand. You got to knock out 50,000 votes. So I think it's unlikely. Courts like stability, etc. All right, let's see here. Shepherd's voice. I got another question. About a month or so ago, Michigan Supreme Court ruled Governor overstepped her power with much of her mandates and said we're null and void. I lost my job on Friday. I'm medically exempt for wearing a mask. State's liquor commission threatened to pull his license if he didn't force all employees to wear a mask. To pull my boss's liquor license, I've worked the whole time without a mask. I have a large shield that hangs, and most of them wear masks. Can they legally do this? I called Michigan Supreme, no one there to answer the phone because of the shutdowns. So, Shepherd's voice. Number one, talk to a local Michigan attorney. Here's what I do know about the masks and lawsuits, all right, is number one, you have had, if you're going to raise anything about it, because there was during the lockdown earlier this year in Pennsylvania, there were a couple news stories, maybe even a couple lawsuits, but I didn't follow them. My understanding was, as follows. My understanding was that you have to have, number one, to get around the mask mandate, you gotta, I was talking about the ADA at the beginning here. you got to fight under the Americans with Disabilities Act. In order to fight under the Americans with Disabilities Act, you have to have a valid disability. So what I would ask what your medical reason is that you can be exempt from a mask, okay? So you have to have a valid disability to be exempt from the mask. Then you have to make sure that you notified your employer of the disability and the reasons for not wearing the mask. And if all of those are met, number one, if you have a valid, legally recognized disability. Number two, if you informed your employer of the valid, legally recognized disability. And then number three, if the sole reason, not necessarily the sole reason, but if one of the reasons they let you go was because you refused to wear the mask and your refusal was because of your disability, you may have a case. You may, in fact, have a case. Now, here's the thing. It's going to be very specific to Michigan, right? Even under federal law, Shepherd's Voice, the different districts, the different federal districts make decisions differently. So you really got to look at Michigan law. And if you bring the case under state law, same thing. You got to look at Michigan state law in order to take a shot at that case. So there may be something there. You calling the Supreme Court, you calling Court of Common Pleas or Appeals Court isn't going to help you, Shepherd's Voice. Okay, it's not going to help you. Thank you for coming in talking to me. You need to talk to a lawyer. And I can tell you the type of lawyer you want to talk to is an employment attorney or a Title VII attorney or a civil rights attorney. That's how these lawyers usually advertise themselves. My recommendation is find a good employment attorney, go online, pull up the website of 3 different employment attorneys and call every single one of them. And if they turn you down or turn you back, ask them to recommend you to someone who they think will take the case and go from there. You may, in fact, be onto something, but I don't know. Remember, I'm just providing useful legal information here, not actual legal advice. I am not licensed to practice in Michigan, okay? So you need to talk to a Michigan attorney, all right? We don't have an attorney-client relationship here. I'm on YouTube sharing legal information with you guys and just saying what comes to my mind. So thank you very much. Listen, Aaron, yeah, I got Diet Pepsi. Look, can Joe change it up once in a while? I think he can. I like most diet beverages. I'll be honest. It's weird, right? It's weird because they don't taste as good. But you know what? If I drink one Coke, one regular Coke, I'm kind of sick. It's so much sugar. I'm like, I'm sick. But I drink 3 Diet Pepsis throughout the course of the day. I don't know if that's good or bad. It's not good. It's not good, but it doesn't make me sick. Yeah, Diet Pepsi today. You caught me. I got a whole 12-pack, so that's what you're going to get every day. So, Shepherd's Voice, I hope that helped you. Please leave me a comment, okay, and like this, and you can sign up for my newsletter as well. You can sign up for my email list in the description below, but I hope that helps. Call an attorney, grab 3 employment attorneys, call all of them. Tell them your disability. The ADA, the Americans with Disabilities Act, has some pretty strict definitions. Not everything that you may think is a disability actually is. But if you have something that is recognized as a disability and that's your reason for not wearing the mask, you may in fact be entitled to protection and you may in fact have a lawsuit for your termination. But I can't tell you 100%. Again, I don't know Michigan law, but I hope my information, puts you in the right direction. CW, hello. Thank you for joining me from Avon, Indiana, the great state of Indiana. It's not a state I've spent time in, but I have a friend there who rides a Harley, and he seems to really like it. Okay, do you think amending 230 would ruin the internet? How likely would it create burdens Facebook and Twitter could handle, but smaller corporations couldn't? James, I just don't know enough about that. Are we talking about net neutrality? We are. Democrats run net neutrality. Democrats on the FCC are taking issue with the G. Pie's announcement. Agent clarified. I got to read up on net neutrality, James. When it was a hot topic in the news a couple of years ago, I really had a nice grasp of it in my mind, but I can't remember everything. So I would have to read up on it and give you an opinion. It's hard for me to give you an opinion right now. I do think that what you're saying may be legitimate because, look, most regulations, most of the time, hurt small businesses the most. They hurt small businesses the most because the large businesses can pay to get around regulation. They have the money and the resources to avoid regulations, whereas smaller businesses often don't. And if it substantially affects their business, it can run them out. Okay, everybody, a little unannounced live stream. I hope you enjoyed my show tonight. If you like my content, like, subscribe, comment, and share. Go ahead, sign up for my email list. Thank you very much. You can check out my other channel too, the Common Sense Academy. I talk about sovereign citizens. This is Joe the Lawyer. Ask a Lawyer Anything. Signing off. Peace and love to all.